Your service with Haber and Martinez. I'm Haber.
The other way.
That's Martinez. How you doing, Ed?
I'm good, man.
So we haven't been live in 5 weeks. We didn't do any shows in the entire month of December.
Taking a couple of aspirin. That's about it. I got a headache at the thought of talking to you.
Yeah, well, that's understandable, although it usually only happens to the ladies. That said, let's clue in the audience as to what we're doing here today. We're talking about trials. We've encaptioned our show today. To go to trial or not to go to trial, that is the question. And of course, we borrowed that from Shakespeare, from Hamlet. And really, it's the same type of mortal choice that Hamlet had, right? You're damned if you do, you're damned if you don't. Is it better to risk a trial? Is it better to not risk a trial? We're going to spend the next hour talking you guys through our thought process, how we evaluate cases as defense attorneys, how we advise clients, what the overriding parameters are. But there's one thing I want you to keep in mind, no matter what we say. This is universally true when it comes to criminal cases. In fact, it may be the only universal truth. And that is every case and every client are unique. So a trial may be good for me and it may be bad for you. You and I can get arrested for the same exact crime, but one of us may have priors, one of us may have a legal defense. The point is every case is different. So you really need to address these issues with your lawyer one-on-one after fully vetting all of the facts and circumstances. But that said, there are a lot of guidelines that Ed and I can give you based on our 55, 60 years of combined experience in criminal courtrooms on both sides of the podium. So with that said, let me start with the basic premise. The first question that I ask in my outline is, who decides whether or not to go to trial? And Ed and I have talked about this a couple of times during the course of At Your Service. There's really only two choices, apart from the choice to hire a lawyer or not hire a lawyer, that a client has once the lawyer is hired. And one of those decisions is whether or not the case goes to trial. A lawyer cannot force a client to try a case. A lawyer cannot force a client to take a plea. A lawyer cannot force a client to do much of anything, even pay fees. All we can do is withdraw if they don't. The point is we can give our best advice, and then it's up to the client to make an informed decision. So what should that tell you? First thing it ought to tell you is you really need to have confidence in the person that's advising you. If you went to a doctor and you had a medical issue and your doctor was equivocating and not talking straight with you, you'd hopefully be a little bit concerned about that doctor prescribing a course of treatment, particularly a surgery. And we can liken a criminal trial to a surgery. Although it's not done with scalpels and anesthesia, many of us wish that it were, especially in that moment.
Well, Mike, I'd like to jump in here and just say
Sure.
something, because it's one of my pet peeves about the profession. There's a lot of lawyers out there. Imagine, let's use the analogy. Imagine that you went to see a doctor and the doctor's telling you ask the doctor, what should we do? And he says, well, I can pretty much guarantee you that if you take this holistic drink and massage the area, it's a 99% chance that it'll all go away and you won't die. And then 6 months later, you have to go to surgery or you're dead. A lot of lawyers will tell you things out there like, I'm 99% sure I can do this, or I'm 99% sure I can get you this plea. And in one of my pet peeves, because there's absolutely no guarantee, I'm sure Michael will agree with me, there is zero guarantee what's going to happen at a trial. And I hate when lawyers do that, or even, let's say, a plea offer when you're arguing, when you're going to negotiate with the state, because they won't put it in writing. And it's really a bad practice, because the client starts thinking this is a sure thing. When a client hears 99%, that's a sure thing. There is absolutely no sure thing about anything you do in life, certainly not when it comes to the law. And any lawyer who says that to you or equivocates with you is a lawyer that you should be very concerned with, or simply ask him to put it in writing. Tell him to put in writing that there's a 99% chance of an outcome, and he won't. And that's why we want to do this show, to show you how complicated these decisions can be. But at the end of the day, what Mike said is right. It's your decision. All Michael and I, or any good lawyer, could tell you is this is our defense. This is the evidence the state has. If we go to trial, I'm going to try and defeat their evidence with this. What do you think? Then they, of course, what they always ask us, Michael, what do we think? And we'll tell you to the best of our ability, but there's no guarantees, and it's a gamble.
Well, at the end of the day, there's one universal truth. Well, almost universally true, because it doesn't always work out this way for some lawyers. But usually at the conclusion of a criminal trial, regardless of what the jury's verdict is, the lawyer's going home. Sometimes they don't go home because, every now and then there's a contempt issue. But, overall, we're going home. So, we want to do the best job that we can for the client. And sometimes the best job that we can do for the client is to advise them that trial is not a good option. And it isn't always a good option. Sometimes it is a good option. But even when
Can I jump in? I think 90% of the times, or the vast majority of the times, it's that the state has given us no other option. And we'll touch on that later in the show.
Right, definitely will. They're like, I have a client right now who's facing life in prison with 22 years of stackable minimum mandatories. He's looking at an awful lot of time. There's a video of the crime. It doesn't look pretty. Still, there are some defenses. We definitely have some points that we can make. There are some punches we can throw. But at the end of the day, is it going to be enough to convince a jury? And I don't know the answer to that question. No, none of us have a crystal ball or a Ouija board or tarot cards, or even if we do, we would be very reckless to employ them in these circumstances.
Wait. You don't consult a babalao with your cases?
No. Yeah, you're my babalao. Exactly. No, but I do, and that's another good point too. You may have all the confidence in the world in me, and I appreciate that. I mean, I've been doing this for 31 years. I've got a little bit underneath my belt, but I still run my cases by other attorneys. And I run my cases by lay people even more than I run it by other attorneys, because I want to know what people who are not trained in the law are going to think. And it gives me a barometer or a weather vane, to be able to kind of at least foresee to some degree what's effective and what isn't. Look, most people can't afford to hire mock juries and trial consultants, to go through those types of exercises pre-trial to really do a scientific study. So we do the next best thing that we can do, right? A lot of times, listen, I'll ask my 17-year-old kid. He's got a completely different perspective that is not evolved and is not really torqued one way or another by the system, because he's never been involved in it. Thank God. Let's knock on some wood. So we try and feel these things out, but when we give you an opinion, that's really all it is. And at the end of the day, anything can happen. So it's an educated opinion, but it's an opinion nonetheless.
Right.
So
let's get into it.
When does the decision to go or not go to trial get made? So a lot of people will start an initial consultation, and some of them will be on one end of the spectrum saying, I didn't do anything wrong and I want my trial, and that's it. We're going to trial in this case. I mean, this is before the case has even been filed. Then you have people on the exact opposite end of the spectrum that say, I don't care what, I will never go to trial, I will never risk a trial, just get me a plea that keeps me out of jail. And then there's a whole continuum in between the two polar extremes.
And I want to jump in here to make it quick. I want to get the two extremes out of the way, okay? Because those are two extreme situations, and that shouldn't be even the main focus, but let's touch on it. One, if a state in a criminal case, if a state offers you a PT, what's called pretrial diversion, either pretrial intervention or diversion, it depends on whether it's a misdemeanor or a felony, but they offer you a pretrial intervention diversion type plea offer. What that means is that you have to take some classes, you might have to pay some restitution, do some community service hours, whatever it is, usually lasts between 6 months to a year while the case is open. And if everything goes well, at the end of your pretrial intervention time, the state dismisses the case. And right, Mike, sometimes we have clients who are like, but I didn't do anything. And we have to explain to them, you're putting your pride, you're biting your nose off to spite your face, because the best possible outcome at the trial is exactly what the prosecutor's giving you. If we go to trial and win, it gets dismissed. He's giving you a guaranteed dismissal. You're just going to have to swallow your pride. That's the one extreme. You wanted to say something, Mike, about that extreme?
I want to say something something you just said about diversion, because sometimes diversion, even though it is a great outcome, it can be defeatist as well. So here in Dade County, diversion is generally pretty simple. But go right across the county line to the north into Broward, and you can't even enter diversion without doing a handwritten confession. you actually have to admit your guilt in writing as a precondition to entering any diversion program in Broward. So do you want a public record of your written confession? Let's say that you're a professionally licensed individual. Let's say that you've got other complications with regards to administrative proceedings or some kind of civil lawsuit. Let's say it was I don't know how you would get diversion in the DUI case, but I'm just throwing it out there. But let's say that it was some sort of diversionary program. I mean, DUI with an accident. Let's say it was an accident and you're being sued. Do you need a written confession in your criminal case that would be admissible in a civil trial? So, sometimes it's not so cut and dry. I had a client not too many years ago. Actually, he was on our show. He was a stand your ground client, Captain Nick, who could not take diversion because he risked losing his pension and being discharged as a result of it. So, these are complications that, again, your lawyer needs to be familiar enough with to vet with you up front because, a lot of people, it's hard to look that gift horse in the face when the state throws diversion at you and you know that you've got a trajectory to accomplish the ultimate objective easy. Sorry, Ed. Go ahead.
Keep in mind that this is one of the ones that are the no-brainers. And Michael's right. It's complicated, right? There's other complications and we can talk for an hour. So I don't want to get too much into that because I know, Mike, you want to go somewhere else. But even PTI is complicated. Now let's look at the other extreme, right? Where the state's best offer is 2 life sentences or a life sentence. I mean,
actually, let's take something a little more close and dear to you that I think is much more easily relatable. A lot of drug cases, even not particularly serious drug cases, come with minimum mandatories. And so when you're offered that min-man, let's say you have no priors, but you're looking at a 3-year min-man because you just happen to have 10 Percocets on you, which is really all it takes to face that 3-year min-man. So if you're sitting there with that 3-year min-man in the face and the state refuses to waive it, you have no priors, right? The state says 3-year min-man, look, you could get 30 on the trafficking charge, but most judges without priors are not going to penalize you, although there is a thing called a trial tax, which we'll talk about later in the show.
That's why I wanted to go to the extreme, because I think this is something we need to talk about. But the extreme one, Michael, where they're offering you a life sentence or 2 life sentences, I mean, why would you not go to trial? Why would you not risk going to trial? The worst that you could get. I mean, what more can you get than life?
Well, when you're looking at that, you actually have an incentive to go to trial,
right?
Because any type of error can be committed. You can wind up with a mistrial, with a retrial, a better plea offer later. Witnesses may say something unexpected. Evidence may wind up being confused or forgotten or misplaced. I mean, anything can happen during the course of a trial. Good or bad can break either way. So if you're in that extreme position, but the one I threw out at you with a 3-year min-man, when you're looking at 30, is a much more complicated task. Because we know now you have to say, when you've got a lawyer who, like, let's say in Ed's case, was a narcotics prosecutor, prosecuted these cases, defends these cases, knows the judges there, knows their proclivities, and will be able to say to you, although he can't guarantee you and will not guarantee you, but he can say to you, you know what? If you come back guilty in this case, the overwhelming odds are this judge ain't giving you 1 day more than the 3-year min-man the state offered you in the first place. So you don't have a disincentive, but that doesn't mean that judge couldn't give you every day of 30, which they can. These are the types of things that go into the calculus when I ask the question, what should one consider when deciding to go to trial or not, and how do you make this decision? These are the types of things that we have to think about here, right?
To be honest with you, when it comes to that moment, right? Because leading up to the actual trial day in Dade County, if it's a state case, we're looking at minimum 6 months to a year if it's a felony, maybe sometimes 2 and 3 years before we get to the trial where we got to decide, are we going to pull the trigger? But once we get there, that's where this comes in, where, Michael and myself, I can tell you myself, I will say to my clients, look, no guarantees, but this judge we know his sentencing habits. And whenever there's a drug min-man, like, for example, we know a couple of judges in that building that hate drug cases, hate them with a passion. And if you get convicted, everybody, including the prosecutor, knows the most he's going to give is the min-man because he has to by law. Otherwise, he'd give you even less, right? We could say to that client pretty strongly, listen, every time you guys a drug case in front of this judge, He gives the min man because that's the minimum he has to by law to do. So if the state is offering you the min man, you might want, and this is how I say it to my clients, you may want to consider going to trial here, but I can't guarantee you that you're going to be you're not going to be the first one that he gives 30 years to, but you decide. So, but this happens right like a week or a month before.
You remember that line from Judge Smales in Caddyshack where he's having that heart-to-heart and he says, I have given a 15-year-old kid the death sentence. Didn't want to, but felt I owed it to him. Right?
That would have been Judge Lenny Glick. Remember Lenny Glick?
We have some judges who are you can absolutely count on them to max you out, and you know it going into it. But again, prosecutors tend to, and we're going to touch a little bit on plea bargaining, but prosecutors tend to tailor their plea bargains to their judges. You know, if a prosecutor knows that they're dealing with an extremely liberal judge who won't max people out and is always looking for a reason to find some, justification to reduce sentences, they're not going to give high plea offers because they're never going to close cases and they're just going to get barked at by their judge all day long. Correct. So they have to comport. On the flip side, if you're in front of a judge that's going to hammer you and the prosecutor knows that, then their plea offers are going to be a little bit harsher because they know they can get away with it. So
going forward,
there's an old joke that says it's better for a lawyer to know the judge than the law, right? So know your judge. I mean, obviously it's a joke. We need to know both, but you got to know your judge because knowing your judge tells you where you're going to fall on that probability scale of sentencing if you ever get it.
Going forward, what Mike is talking about for the prosecutor is what's called knowing the value of your case. As a prosecutor, you need to know the value of their case. And as we go forward, keep this in mind. The sweet spot for the prosecutor is the most amount of time he can get for that defendant that makes it a difficult choice for the defendant. In other words, the sweet spot is that number that you're like, it's a little bit high, but if I go to trial and I get convicted, it's a lot worse.
So it's like in that 3-year min-man case, or let's take drugs out of it. Let's say that it's an aggravated assault with a firearm. That's a 3-year min-man, right? It's a 5-year felony and a 3-year min-man. And let's say the state refuses to waive the min-man. So you go to trial, you get convicted, you have no prior criminal history, and you had a halfway decent defense. The overwhelming odds are not too many judges are going to give you more than that 3-year min-man. Right. And you may even be able to find a way around that min-man at the end of the day. We'll talk about mitigation as well and statutory mitigation. But let me talk for a moment about the odds of acquittal, because I do have those statistics and I did put them in our promo. And statistically speaking, I'm sorry, but I'm reading this off of my promo. In criminal cases, less than 2% go to trial in federal court, and less than 3% go to trial in state court. Most are resolved by way of plea bargains. Some are resolved by way of pretrial motions, whether it's a motion to dismiss or a motion to suppress or a motion for statutory immunity, stand your ground, what have you. And then more and more of them are now being resolved by way of diversion, which has become much more popular, although there is no diversion in the federal system as far as I know. So the question now becomes, what happens to the balance of those cases? So statistically, again, in the criminal cases in federal court, the conviction rate is 93%, which means that out of the 3% of cases that go to trial, the 2% of cases that go to trial, only about 7% of those result in an acquittal. So of that very small percentage of cases that go to trial in federal court, a slightly larger percentage, 7%, actually come out of the courtroom found not guilty. In state court, the numbers are just slightly more favorable. State court has about a 75%, in Florida, about a 75% conviction rate in felony cases. Right. So if you're just going to go by the numbers are the house wins, just like in any casino. The overwhelming odds are, if the case goes to trial, you're looking at a conviction. Doesn't mean you are going to be convicted, but again, if you're just talking statistics, that's where you wind up statistically. Right. Do you want to say something?
there's really a reason for that. Well, first of all, I want to say one thing quickly. The reason the percentage is higher in the state court, and Michael and I know this having practiced law, is federal prosecutors don't take anything to trial unless it's a slam dunk. Where state court prosecutors are a little more liberal on what they believe they can prove beyond a reasonable doubt. So it
I'm
has
gonna
to do
I'm
the
gonna agree with that, but I'm gonna add something that I think is even more important to it. The vast majority of federal court cases are thoroughly investigated before there's ever an arrest made, whereas the vast majority of state court cases, the arrests are made in the moment with no investigation. Right.
and it's
So
just
normally,
it's a
if you have
product.
a money laundering case, if you have a racketeering case, if the feds will let you go on and conduct whatever criminal
Well,
act
the reason I bring it up, Michael, and thank you for pointing it out because you're right. And the reason that happens is, one of the things that I look at, I'm sure Michael does too. When we look at a client comes to see, the first thing I look at the docket to see if this case is in a special unit in a state court case, or if it's in what we call the pits. And why is that important? Because a special unit prosecutor is more like a federal prosecutor. They investigate these cases before an arrest is even made. So by the time you're arrested, the prosecutor can go to trial literally the day after you get arrested because it wasn't a spur of the moment kind of arrest, which is what we call a probable cause arrest. So again, just like the prosecutor needs to know the value of the case, Michael and I, we need to know the value of this case. So when the prosecutor comes to us with a plea offer, we know whether that's something good and reasonable or not. And one of the things we look at is who's got the case? Is it a special unit? Is it a pits? Is it a chief in special unit? Or is it really still just in the pits? These are little things that we all have to consider because we know that if it's went to a special unit, there's a reason it's there. Either my client has been on their radar for a while, my client has priors, or my client's a pretty big deal in whatever area of crime he committed.
So we have to take that comprehensive approach, and that's part of what we talk to our clients about. It will dovetail into everything. It will factor into plea negotiations, and again, we could go back to that that drug offense, because before any minimum mandatory gets waived here in Dade County in a drug case, somebody from the narcotics unit's going to have to sign off on it, right? Even if it's most of the cases are handled by pit prosecutors, but that's only because the specialty unit has designated them back into the pits and said, we don't need to deal with this particular case. It doesn't require our attention. UCBA prosecutor can handle it. And that's how they go. But still, in order to waive that min-man, for the state to come and make a formal offer, they're going to need approval.
Correct. And it weighs into our what we discussed because, again, if they come back with, let's say, a 15-year or 7-year min-man on a drug case or any other case that has a minimum mandatory, the first question we have to ask is, have you spoken to a special unit? Have you negotiated with them as the prosecutor? And if we don't get a result, we have to sometimes say, can we talk to them? Because, you're asking the way the system works, generally speaking, is the prosecutor is the first one that has to go ask for a minimum waiver a minimum mandatory waiver. And we're putting your life and that spiel, that speech that we want to give to the chief of whatever unit in the hands of a prosecutor. But that's the way you got to do it. And if you don't get what you want, then Michael and I have to very delicately and professionally ask if it's okay if we can go talk to the chief as well, because we'd like to pitch it ourselves. So it's not as easy as you guys think. And there's a lot that goes into it to get a good plea.
And you don't always get a good plea.
You don't.
That's what dovetails us into our trial situation.
Right.
If you're that guy, let's say that you have a road rage incident and let's say it happened. Let's say it truly happened. Okay. I'm in a foul mood. Things are not good in my life. I'm having a really bad day. Martinez cuts me off in his big ass truck and I, blow my horn and he shoots me the bird out his window and I lose my mind and drive around the side and pull my gun on him. I don't have to discharge that weapon. I've just committed an ag assault with a firearm and I'm looking at a 3-year min-man. It's really that simple. And in order for that 3-year min-man to go away, it's not enough for me to say to a prosecutor, or maybe it is, depending on the prosecutor, I suppose, but it's not enough for me to say to a prosecutor, look, my client was just having a really bad day. He's otherwise a good guy. No, there's a 3-year min-man sitting there. And the overwhelming odds are that the only way that 3-year min-man, not the overwhelming odds are, the fact is, the only way that 3-year min-man is getting waived is if the victim approves it and the prosecutor feels like doing it. So,
Correct.
those are the two hurdles that you have to jump. We get this a lot in lower level cases. I'll give you a great example. Resisting arrest without violence. That is a misdemeanor offense. What it means in effect is a cop told you to do X and you did Y. All right. So let's say, for example, Martinez has a son, and his son has an automobile accident. The son calls him and says, "Dad, I just had an accident." And Martinez runs over to the scene. And by the time Martinez gets there, the cops are already there. And Martinez wants to go see how his son is. That's his concern, right? So he goes up and he's like, and the cops say, "Sir, get back." He's like, "No, this is my kid." "I get it, sir. Get back. We're conducting an investigation." Martinez continues to persist. He's going to wind up in handcuffs in the back of a police car. That's called resisting arrest without violence. That's what it is. So it's a pretty simple offense. Now, the victim in that case is the cop. The cop may have a chip on his shoulder or her shoulder. And if that is the case, how are you going to get diversion when you have a police officer insisting on no diversion?
As a matter of fact,
you've got to talk to that. Go ahead.
You won't get diversion in a situation like that many times simply for the fact that the officer is concerned that if he had to, for example, suppose he says to me, "You can't go see your daughter," and I put up a fight. I struggle with him, and he has to throw me to the ground, and I get, a scratch or on my eye or my forehead or any kind of an injury. He's terrified that after the case is dismissed, that you're going to sue him and the department. So he doesn't want to do it because it's a dismissal, which then you'll come and say.
So here's how I handle that as Ed's attorney.
I know how I handle it. I just don't want to. I don't want to get your secrets out there.
Real simple. I tell the prosecutor I understand that completely, and that's why my client is going to handwrite a very sincere apology letter to this officer that will be incorporated in the court's file, and that's the end of any civil lawsuit. So. But again, Ed brings up a very good point. And it goes back to the first thing I said, or one of the first things I said, which is every single case and every single defendant are unique. You can't just throw that blanket umbrella over a charge or even a person and say this is the way it's going to be, because it's not necessarily true. And your lawyer really needs to understand the dynamics of the situation, the entire calculus, in order to come up with the right answer for you in this case. The answer may be different in another case.
Let me give a war story quickly that'll illustrate a lot of what we're talking about, all in one case. So I had a client that hired me. He knew me. He hired me because he had gotten arrested on 4 fraud cases. Okay. He was accused of being a con man. Every fraud was a little bit different, right? So he hires me on these 4 cases. It's in a special unit. So immediately I tell them, "Listen, you got an economic crimes prosecutor. That means they're coming for you. They don't think that you're just a one-off. They think you're a really bad guy." Okay. So I go see the unit prosecutor and I'm starting to talk to him about pleas. And the first thing he says is, "Well, we've got 3 other cases pending that we're ready to go get him and hit him with an arrest warrant with like 7 other victims where he stole their money too." He says, "But I'm willing to plead this case out and not add those victims because they knew my client didn't have the money to pay everybody back. So they wanted him to do some prison time." And I said, "Okay, well, let me negotiate with you and please keep that at bay. Don't add those 3 cases. I said, "But one of these 4 cases has got to be dismissed." "No, Ed, we're not going to dismiss it." I said, "You're never going to get a conviction on this one case because the co-defendant should have been the victim's son." Right? One of the issues was that the family, the 2 victims, elderly couple, wrote a check for $150,000. That turned out to be fraud. But the son is the one who cashed the check, their own son. So when I did the discovery, I said, "How are you going to get around the fact that the son was in on it? The son cashed the check. You're not going to get around that." So I filed the speedy that you love to do, but I rarely do, because I was sure this case was a slam dunk. Sure enough, the day of trial, they had to dismiss the charges. So now he's left with 3 and 3 pending, right? He's sitting in Dade County Jail. And this is what it's an all-encompassing thought. I said, "Listen to me. If you take the 5 years," he was like, I'll take it. I'll take it. I said, "Just relax. Why are you going to take the 5 years now when you're sitting in Dade County Jail? They had made him a trustee. He used to run a Friday night poker night that the guards would let him run a Friday night poker night." Okay. Yeah, I know, right? His life was super calm. He didn't get into fights. Everything was wonderful. I said, "If you go away, you're going to state prison with guys that are lifers that have nothing better to do than shank people because they're bored. Like, are you out of your mind? Just stay here." No, go ahead, please. I said, "The other cases are a little bit, you got 2 cases you're going down for sure, and they were all first-degree felonies." I said, "There's the The other case, there's one that's a little weak. That's the one I'm harping on with the prosecutor because I'm trying to use the fact that that case sucks too to get him to give you less. Maybe I can get you 4 or 3. And if I can get you 4 and you're sitting in Dade County Jail for 2.5 or 3 years, it basically becomes credit time served and they never even send you to state prison. They'll keep you here for the remainder of. So all this is what I'm working on. And he's desperate to close his cases out. So he doesn't listen to me. He hires somebody else who's been around for a while. If I told you the name, you know exactly who it is. Because he came in and told them that that one case that I pointed out sucked. Yeah, I know. But you got 2 there and you got 3 hanging out in the wind. Long story short, Michael, about a year after he got the new lawyer, he ended up taking a plea to 10 years with 6 cases. Because he was in a hurry. You
can lead a horse to water, Ed.
It's like a chess game. This is what I always tell my clients. Am I wrong, Michael? The whole process is a chess game. You've got to be patient. And sometimes Michael and I have to wait for the state to make the move so that then we can make our move. Because we got about 6 moves we're ready to make. But 5 of them would make our case worse. So we wait to see what the hell they're going to do so then we can decide which one we're going to do. And sometimes you just have to be patient. And it's always on the defense side to be patient. Remember that 99% of the time, and I know I hate saying that, I'm not going to put it in writing, but certainly the vast majority of the time, the state's case does not get stronger.
Over
no matter how much time it goes on, it doesn't get any stronger.
Now, witnesses vanish, witnesses get arrested, evidence gets lost,
get weaker, including the lead detective getting arrested. He might get arrested himself, and then their case goes to shit. Pardon my French. I don't know if you know that shit is a French word. So be patient because it gives us time to analyze the chessboard.
So there's only 4 possible outcomes of any trial. Now, again, we're assuming that you've gone to trial at this juncture. You've decided to go to trial and you've gone to trial. You can be acquitted, which means you were found not guilty. You can be convicted, which means that you were found guilty. You can have what's called a split verdict, which means you were acquitted of some charges and convicted of other charges. Or you can have what's called a mistrial, meaning that there was some fundamental error during the course of the trial that caused everything to come to a crashing halt.
Like even a jury just not being able to come up with a unanimous decision. That it's just,
let's actually talk about that because I have that right here ready to go. So when a jury can't reach a decision, it's called a deadlock or a hung jury. And there's a United States Supreme Court case called U.S. v. Allen, which resulted in a thing called an Allen charge, which is sometimes referred to as a dynamite charge. And when the jury comes back and says to the judge, look, judge, we've been deliberating and we just can't come up with a verdict. We can't reach, because verdicts have to be unanimous. Can't be a majority or a plurality. It's got to be everybody. Either 100% agree to acquit or 100% agree to convict or 100% agree to acquit on some and convict on others. But in any event, it's a 100% pure agreement by the full jury. When that doesn't happen and the jury's had enough, they send a note to the judge and say, Judge, we can't reach a verdict. Well, at that point, the judge can read them standard criminal jury instruction 4.1 called jury deadlock. I'll read it to you exactly because it's pretty short. I know that all of you have worked hard to try and find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are 2 things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is, as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree about what you believe the evidence showed, then only you can resolve the conflict if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room. Then, taking turns, tell each of the other juries about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you has had a chance to talk. After you have done that, If you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your service. You may now retire to continue with your deliberation. So what that is, as you can tell, it's an effort by the court to salvage the time and resources that were put into the trial. Nobody wants to start over. If there's a mistrial, then the case literally starts over as if it never happened. Now, you do have some things that were set in stone. For instance, you have testimony that was given already, obviously. Evidence was already admitted, obviously. There will be transcripts of all that. So if the case is retried, both sides will have, some tools to their advantage or disadvantage, depending upon how the facts and circumstances fell during the course of the case. But at the end of the day, we want a verdict. Everybody wants a verdict. So let's talk about what happens now. What is it like to sit in a courtroom waiting for that jury verdict? What is that phenomenon like? I mean, I don't know if you've ever had to go for a procedure like, I don't want to be gross, but a colonoscopy, right? You schedule it for 7:00 in the morning. You have to do all that prep work, the day before, the night before. You have to get yourself to the hospital. You haven't eaten, you haven't drank anything, or to the outpatient room, wherever it is you go. There's some trepidation, right? You have to enter, you have to be admitted, you have to fill out paperwork, you have to sign waivers, you got to talk to an anesthesiologist and a doctor and nurses. And, especially if you've never done it before, if it's your first time, but even if it isn't your first time, it's kind of a nerve-wracking process. And that's kind of I guess I can liken that colonoscopy to getting to the point of sitting in a courtroom waiting for a jury to come back with a verdict. You've done all of that horrible prep work, and now you're just sitting there waiting for the results, right?
And it is nerve-wracking. And there have been times when I was a prosecutor that I had somebody had a lot of priors, was very familiar with the system. So they tried to safeguard themselves against getting arrested. And it was a difficult case, but it was a really bad person with a lot of priors. And, while I felt I could prove it beyond a reasonable doubt, I realized that this was a tough case. And I would always tell the defense attorneys who would come in and say, you're going to lose. Or sometimes, believe it or not, Michael, defendants would tell me as I'm walking in, you're going to lose. Like I'm scared. Like I'm not going to prison if I lose. But I would always turn to the smart asses that would say that to me. And I'd say, you know what? You're probably right. Maybe I will lose, but I can guarantee you this. For the next 4, 5, 6 days, your ass is going to be sweating in that chair every minute when the jury keeps hearing about what you did. And I knew that. I knew that it made them squirm. And I knew also there's and I don't know if you touched upon it on your outline, but one of the reasons I did that is sometimes these cases get played out in the middle of the trial, right? Sometimes the defendant sees that this thing is going bad for him and he wants to take the plea, or
the state.
Or the state says, you know what? I didn't know that. I didn't know this. This case is falling apart. Let's try and plead it out.
Hold that thought for 1 second, because that's really important. And again, that's something that we said early on, and you need to always bear in mind. It's like Fight Club. There's one rule of Fight Club, right? Don't talk about Fight Club. There's one rule about criminal defense litigation, probably true about all litigation. Expect the unexpected. Anything can happen. You never know what's going to happen during the course of a trial. So this is one of the things that we have to consider when we're advising a client, right? You need to think about these things before you get into it. You can't reasonably foresee everything that might go right or everything that might go wrong, but you certainly can see some of it. So when you have that client who's on the edge and they're like, I don't know whether to go to trial or not, I'm not sure what to do. Well, the question then becomes, where do you fall on that plea continuum and how hard is it going to hit if you come back guilty? Because that can be the decision maker. And if you get lucky and you have nothing to lose and you may as well go to trial, if you're in that extreme that we talked about earlier where you're looking at life anyhow, like let's say you're a prison release reoffender, you're a perp, you're in rock court, you've got alphabet soup behind your name, you're a red file, you've got 16 prosecutors and 47 marshals in the courtroom, you may as well go to trial because anything can happen during the course of that trial, including the prosecutor having to throw in the towel.
And you said something very interesting, Michael. I forget who I was talking to the other day. They were asking me, why should I make sure that if I hire a lawyer on a criminal case, in any case, really, that I asked them when was the last time they were in trial and that they're pretty trial active. And that's because what really makes a trial lawyer a really good trial lawyer is that he can handle. Now, hear me out. Not that he knows to expect the unexpected, because anybody can do that. But the good trial lawyers can handle the unexpected.
Pivot
Okay.
with it.
And the better ones can handle it better than others, right? So, and there's another caveat to that. As a former prosecutor, I think we've talked about this in other episodes. If I'm going to trial against Michael, remember I told you the value of a case? Well, something that impacts the value of my case is who the defense attorney is. It's truth. If I know that Michael will never go to trial because he hasn't been in trial since like the third week after he got out of law school, okay? He's been doing this for 30 years, and we talk to each other amongst the office. So don't think we go to people. Hey, you know Michael Haber? Yeah, does he ever go to trial? Nope. Does he ever go to trial? Nope. Has anybody ever been in a trial with this guy? Nope. You know he's going to sell my plea, so my plea goes up a little because I know Michael's not going to fight me. He's going to be an ally. He's going to be in the hallway yelling and screaming at his client that he should take the plea. However, if
It's
Michael's
amazing how many defense attorneys fall into that category.
Usually the ones who charge less because they know they're never going to go to trial, but they lie to their clients. But if I know Michael goes to trial, now I'm looking at this case and go, all right, I got a little bit of a problem. Michael's going
to have to assess. You have to assess the case as a prosecutor, but also as a defense attorney. And either way, it's the client ultimately that winds up in that hot seat, because, like we keep saying, at the end of the day, absent a contempt ruling, both lawyers are going home. I'll tell you, my first jury trial that I did was the year that I became a lawyer. It was a DUI case. I was in front of a now retired judge who was in county court at the time. The prosecutor had graduated law school the same year as me. He had no more experience than I. We were both rookies. It was I want to say fun, but it was also scary. It was very nerve-wracking. I mean, look, I've done 50 jury trials, and I still get nervous before a jury trial. I mean, they're no matter how comfortable you are, they're intimidating experiences to a certain degree. But in any event, so we do this trial. My client, after 2 days, the jury winds up coming back guilty. And what do you think happened after the trial? And we're going to talk about custody.
You and the prosecutor went and had drinks.
Exactly. This client was not taken into custody. He was allowed to go home. We dealt with the sentencing at a later date. But the prosecutor and I went to Tobacco Road and had drinks and dinner and laughed and joked about the trial.
All the time. It's changed a little bit, Michael, and I think you'll agree with me in the last couple of years, maybe 10. But when I first started 20 years ago as a prosecutor, there was only like a handful of defense counsel that, as prosecutors, we were like, I want nothing to do with that guy or woman. Most of the defense bar and the prosecutors, we got along. It was professional. Nobody did anything unethical. Michael might cry to me, come on, Ed, I can't sell a 15-year min to my client. You're killing me. I'd be like, well, Michael, I don't know what to tell you, bro. You should have charged him more money. It is what it is. I can't do it. And we would still, you see, he's laughing. We would get along. Because there's no, especially in criminal. Now, it's different in the other worlds of the law.
It's so funny because, I mean, I was doing this 10 years before you. And at that time, the coffee house in the criminal courthouse was like a frat house. It really was. I mean, judges, prosecutors, bailiffs, cops, court reporters.
It was like that when I started.
Howled around, yapped, bullshitted. Back in the days when I started,
vast majority of pleas were worked out.
Many of the judges had bagels and donuts and coffee in their chambers, open door policy for anybody to come in. In fact, they encouraged people to come in, not only to come in, but to come in and talk about the cases, because we were able to resolve stuff before we ever got into the courtroom.
And people were open.
I don't remember having those types of negotiations in the coffee shop, to be honest, but we certainly had them in chambers. And then, of course, there were, a handful of judges, the God bless them, the Pineros of the world, that would sit everybody down in chambers and say, nobody's leaving until we work out 75% of the cases on this docket. So, those were the days, right? But again, going back to the clients who are in trial posture, and you're actually in a trial, all of that fraternity is on the side because you're in it right now. I mean, you're not going to see. Look, it's not like we're not. It's adversary, but it's not gladiator adversary. Okay, you don't have two lawyers
Tell
sitting
people,
in an arena.
let me tell you what it is, okay? And I recently saw a story about Kobe Bryant doing this. It's like Major League Baseball players, NBA players, brothers that play against each other on separate teams. What do you think? They're pulling punches? They're not pulling punches. This is what we do. And my job is to defend my client to the best of my ability, and I will do it every single time. I don't care who the prosecutor is. It makes it more enjoyable if he's my best friend because we can have good time during the breaks. And to be honest, Michael, you had siblings, right?
Yeah.
There's no better rush than beating your own brother or sister at something. So you think I'm going to lay down and if I won't lay down for my own brother, you think I'm going to lay down for somebody I met 5 years ago, 6 years? Absolutely not. We are going to fight, and I expect the prosecutors to fight. When I was a prosecutor, I expected defense attorneys to fight, but there's nothing dirty, nothing underhanded. If Michael finds out something in the hallway right before we come back to trial, he'll say, "Hey, Ed, I got to tell you, I'm going to go up and argue a motion right now that just came up because this is what happens as soon as a judge takes the bench." That's what a friend does. If he's not my friend, he won't say shit to me. And when the judge comes on the bench, he's going to jump up and say X, and I'm going to be caught like, what the hell's going on? But it's still going to happen. Exactly the same exact thing is going to happen. It's just, how does it happen? And in criminal, it works that way. Now in civil, Michael, and family, it's different. And the reason it's different there is because the lawyers are getting paid more money depending on whether they succeed or not. And that's why I say it's civil and criminal and criminal and civil.
Right. That's what I was going to say. It's interesting to me that the fraternal nature of the criminal system, even though it's not as I'll use the word fun today as it was, 30 years ago. You go over to that civil courthouse and it is anything but civil. I mean, that's like, it's a bastion of discomfort, anxiety, nastiness.
And greed. It's all greed, from the lawyers to the clients, everybody.
With very rare exception, in the criminal courthouse, we all get it. Look, some people are just going to rub you the wrong way. And there are certainly some prosecutors out there that I would love to take into an alley with no cameras. And I'm sure that there are prosecutors that say that about some defense attorneys.
They say it about us. And I get it.
Overall, as an overriding thing, I think the vast majority, the percentages favor that it really isn't that way. We're really not at each other's throats, even though we all want to win.
Correct. We all want to win, but we do it nicely. And the story I was going to tell you about Kobe, apparently LeBron James and Dwayne Wade and all the guys that were on that Olympic team, the first game that they played against Spain, which Pau Gasol was on Kobe's team in the Lakers, and they were good teammates. And I don't even know if they won a championship together or not, but they're very good friends and they're teammates. And according to what their story, and they showed the video, it happened. Kobe Bryant said before the game, he knew that the first play they were going to run was a screen where he was going to screen off Kobe. And Kobe has two choices: run around Pau Gasol or run him over like a Mack truck. And he said, I know what they're going to run. They're going to run that play, and I'm going to run him over. I'm going to run right through him. And LeBron and Dwayne were like, he's not going to do that to his best friend and teammate. It's the Olympics, but come on. Sure enough, first play, he knocked him almost to the stands. And when they asked Paul after the game, what did you think about that? He said, I would have expected nothing less from Kobe. He wasn't offended. He knew it was going to happen. And that's probably why he loves Kobe, because he knows Kobe's a player. The same thing happens, at least for me. I can tell you that my best friend could be the prosecutor. I'm coming with my A game. I'm always going to come with my A game. And then afterwards, we can have drinks. But when the trial is on, it's on.
So let's get back to sitting in that courtroom when the jury, you get the note that comes in, or you get paged or called or whatever, and told to come back to the courtroom because there's a verdict. And so everybody's sitting in the courtroom. You got the state at one table, you got the defendant and the defense counsel at the other table, you got the judge and the clerks sitting facing you, and now you're just sitting there as time ticks, waiting for that jury to walk in and read that verdict. And the truth is, sometimes you feel really, really good about it. Sometimes you feel really, really bad about it. Most times you don't know what to feel about it, because you know that, again, even the best case in the world can go right down the tubes, or the worst dog with fleas can come out as an acquittal. It's the strangest things happen with juries. So in those moments, the client should be nervous. The lawyers are generally nervous. The verdict has already been reached, so it's not like you have to have a poker face on at that point in time, right? I mean, during the course of the trial, you're constantly nudging your client, reminding your client, don't smirk, don't smile, don't be a jerk, don't give the jury a reason to hate you, you know, be stoic, be a robot, take this seriously, don't let anything get under your skin. If you have something to say, write it down on a piece of paper, give me a note, you know. You always want your client wearing that poker face, but when the jury's coming in with a verdict, it don't matter anymore. It's already written down, signed, sealed, and delivered. And how are those moments? How do you describe those moments? What are your adjectives?
You know something, Mike. For me, it was different as a prosecutor, as a defense attorney. As a prosecutor, I can tell you, I was never once was I nervous as a prosecutor waiting for the verdict, because I really honestly believed. Obviously, I wouldn't have gotten a trial if I didn't think the guy was guilty. So that's number one. Top of that, I needed to make sure that I thought he was guilty beyond a reasonable doubt. But then lastly, I really believed, and maybe this was helped me, and not everybody could take advantage of it, but I really believe that there is a God, and I think that God was going to make this, the outcome of this was going to be whatever he wanted.
Yeah, well, I'm gonna pivot off of that real quick, because I wish that, well, let me say this another way. I've had all too many clients who have, in all seriousness, I mean, without joking, with complete seriousness, have said to me, it doesn't matter, God, Jesus is with me. I've got God in my corner, and that's fine. I have nothing against faith. I think faith is a good thing. But when you're telling your client X and they're telling you, don't worry about X because Jesus has my back.
Well, that's different.
Yeah.
I always asked them to do me a favor. Can he give Jesus a call and have him come down and be second? Have him come down to be second chair because I need his help. No, but seriously. And now listen, as a prosecutor, I was saying as a prosecutor, my mind was set was I do my job and I do it ethically and I do it to the best of my ability. And I give the defense attorney every possible thing he wants within reason. Obviously, that's legal so that he can defend his client, because I want to go home and sleep at night. But if the jury comes back not guilty, to me, that was God's intervention. I don't care. I don't lose sleep. Now, as a defense attorney, it's a little different because you get to know your client. And even if he's guilty, sometimes these guys are guilty, but they're not guilty of what they were charged with. Or, as Michael pointed out earlier, the prosecutor wants to give him a 15-year min when it's like, oh, come on, man. This guy's not that guy. This guy should be getting probation. And it becomes a little more personal. And I do have butterflies. I do sit there thinking, oh my God, they come back.
And I agree with that, because that, one of the things I tell my clients or potential clients before they become my clients, to the prosecutor and to the judge, they are nothing more than a number. They're F22, 1, 2, 3, 4, 5. F23, 1, 2, 3. That's who they are. They have no other identity. They don't exist. Right. They are simply a statistic. They are a file.
And a prosecutor will allow his emotions to get involved. So he's gonna be a number.
For us, we have the exact opposite, because we need to personalize our clients. It's one of the reasons why during the course of a trial, or even at motion calendar or anything else, prosecutor's never going to call my client Mr. Martinez. He's always going to say the defendant. Whereas I'm always going to call my client Ed or Eddie. Or if the judge insists that I not use a first name and admonishes me, after he admonishes me in front of the jury, which I'm going to make him or her do, then I'm going to call him Mr. Martinez. But it's always going to be a person, because we have to personalize our clients. That's part of our job. Correct. We have to humanize them. And in that process of humanizing them, it becomes important to us, or it should. If it doesn't, that's a problem.
And let me be crystal clear, because I said something, I don't want to be misunderstood. When I said a prosecutor has to see the defendant as a number, he cannot get emotional. It cuts both ways, right? If the prosecutor thinks that the defendant is a complete and total asshole, he shouldn't be giving him a plea that's harsher because the guy's an asshole, right? The plea should be based on the case and the facts of the case. That's what it should be based on. And it's priors or lack of priors and things of that nature, not on whether or not personally you like the guy or not. And so a good prosecutor tries to keep those things out of the way so that they can be consistent and be fair.
Let's go back to trials and not pleas.
Okay.
So the jury comes back with a verdict. Let's say it's a guilty verdict. What happens at that point?
The sentencing.
The next phase after a guilty verdict is sentencing. A judge has to decide what to do with you. Jury's job is to decide whether or not, based on the law and the evidence as they view it, you are guilty. If they find that you're guilty beyond a reasonable doubt, the state's met its burden, they find you guilty, they return a guilty verdict, the next step is sentencing. So the question is, when does sentencing happen? And when does a lawyer start thinking about sentencing? Me, I start thinking about sentencing during the initial consultation.
Me too.
It's always in the back of my mind.
Always.
And I have a client that the case is progressing and it starts to look like it's going to be a trial. I always bifurcate my effort and thought process, and I start working on mitigation just in case. So a sentencing hearing is an opportunity for a judge in criminal court to decide what punishment is appropriate given the facts and circumstances of the case. And both sides are entitled to present some degree, depending upon the severity of the case and the tolerance of the judge, some degree of evidence at a sentencing hearing. Maybe you want to bring in family members or friends or employers or people who know the defendant to testify as to his character. That's generally not relevant in a trial because it's not evidence as to whether or not this person committed a specific crime, but it is entirely relevant to sentencing as to what type of person this is and what should the judge be doing with them. Judges generally have a great deal of discretion with regard to sentencing. That means in a given case, absent a minimum mandatory or mandatory sentencing guidelines, judge could do anything from walking you out of the courtroom with a slap on the wrist to probation to jail time or prison time in the vast majority of cases. And the question then becomes, when does that happen and what does the judge do? So the when of it is pretty simple. In a minor or an insignificant case, many judges will ask to proceed to sentencing right then and there. But you can always ask for a delay, and you can always say to the judge, Judge, we're asking that the case be reset specifically for sentencing because we'd like to present testimony and evidence for the court's consideration. But that opens up a potential for the judge to then decide, okay, no problem, Mr. Haber. We'll set sentencing out in 30 days. Bailiff, please remand the defendant into custody pending sentencing. So you really need to know whether or not your judge is going to take you into custody, and that's something the judge is generally not going to tell you up front. You're not going to find out until after the fact. Again, very important reason to know your judge and your judge's tendencies. For example, there are a couple of judges that we know have a blanket policy of taking every single person who is found guilty or pleads guilty into custody. It's not so often in state court as it is in federal, but again, some judges have that proclivity, others do not. Very important.
They let you have furloughs too. I've had several federal.
Well, have you ever been in front of Dimitri Elias in Broward?
No.
Okay. In front of Dimitri Elias, it's a blanket policy. If you enter even at a change of plea, forget a trial. If you change your plea to guilty, you get remanded that day. You don't get to surrender.
Judge Hunt in federal gave us a furlough for husband and wife.
Some judges will, some judges won't. But again, these are things you need to think about. And another little trick of the trade, one thing that we do as defense attorneys sometimes when we have a judge that wants to take our client into custody and we have a compelling reason for him not to go into custody or her not to go into custody, we will offer to agree to a sentence of the statutory maximum with a furlough, meaning you can sentence my client to 30 years in prison today. Just let him surrender in 30 days. And if he doesn't show up and surrender in 30 days, or if he gets in trouble within that 30-day window, he's stuck with the 30 years.
Right. But when he comes back in front of the court will mitigate and give him the appropriate sentence. Yeah.
Exactly. So that's a little, trick that you have in your toolbox if your judge will allow it. But again, we just did a misdemeanor trial a couple of weeks ago, a domestic violence case where the judge took our client into custody. And I mean, it's not illegal for the judge to do it. It's not unheard of for the judge to do it, but it was thoroughly unnecessary for the judge to do it. It was really, I thought, punitive and not rational. However, it's the judge, and that's the judge's courtroom and the judge gets to make that call. So we may not be able to tell you that, but, normally we will tell our clients in a much politer way, listen, you may want to bring your toothbrush to court with you because we don't know what's going to happen. You need to be prepared. That's the bottom line. And it's not, look, we don't want to smack you in the face with reality, but we also can't sugarcoat it too much. we have to give it to you in real terms so that you do understand, because that's the only way you can really make that intelligent decision whether or not you want to go to trial. I really wanted to talk about mitigation, but I think we're going to do another show exclusively on mitigation because we're out of time already.
A lot for
Huh?
I said there's a lot there to do a mitigation.
Yeah, we'll do a show specifically dedicated to the concept of mitigation. But in the meantime, I hope that we've given you some insight into the trial process with regards to how do you make that decision and what happens and how does it work mechanically.
And I got two tips before we sign off. 2 pro tips
Sure.
if you need more. One, this is why it's essential, and I can't stress that word enough, for you to be always tell your lawyer everything, the truth and everything that he needs to know. Because as you see, there's a lot that goes into our strategy just in the prepping part, trying to get a plea or whether we're going to trial. And number 2, it's essential as well that your lawyer be honest with you.
Mhm.
Your lawyer has to tell you the truth. So don't get offended and don't think that your lawyer is going to sell you down the river or that your lawyer sucks because he says, listen, if we go to trial, there's a good chance we're going to lose. He may be wrong. Maybe he's wrong. Maybe he is a bad lawyer. Maybe he's scared to go to trial. But you want him to tell you the truth because you need to know. Your follow-up questions would be why. But you always want a lawyer who's telling you the truth because it's your life, man. You're the ones that have to make that decision.
With that, I want to thank everybody for paying attention, tuning in, listening to our discussion today. I hope that we've given you some good pro tips and truly been at your service. We're not going to do a show next week because it's Dr. Martin Luther King Jr.'s Remembrance Day, and out of respect for the good doctor, we're going to remain silent and let him have his day without us chiming and chirping over him.
Well, I get to celebrate it with him.
We'll be back.
Birthday.
We'll be back the following week on the 23rd with episode number 58 of At Your Service. And we will do a show. I don't know whether it'll be episode 58 or not, but we will definitely do a show on mitigation. We'll bring in a mitigation expert to help us along with that. Ed, thank you very much for your time today. Appreciate your getting dressed up and talking to us.
Always.
And we will look forward to seeing you in 2 weeks on the 23rd, where Martinez and I will be back at your service. Thank you again very much. And we will get these things, this webisode, this podcast uploaded to YouTube and put the link out as quickly as possible. Thank you again, y'all. Happy New Year. Have a great 2 weeks, and we'll see you.